Station 1370 WOCA.
Ocala.
All right, 25 minutes before 11 o'clock. Thank you for tuning in. Going from one subject I don't know much about to another one I don't know much about, from the stock exchange to law. Both topics are always elusive to my understanding. This show is called Legally Yours. The man who knows his stuff when it comes to the law is in the studio. He is John Fuller. He's an attorney here in Ocala at the law firm of Fuller and Fuller. The other Fuller is his beautiful wife, Janet. And John is here right now. And let me tell you the date so that you know if you're listening to a live show. Today is Wednesday, March 5th. 2014. If your calendar says that it's March 5th, then you're listening to a live show. And the number to call if you'd like to speak to John is 622-9622. That is the WOCA Climate Control Source Hotline, 622-9622. Good morning, John. How you doing?
Good morning, Larry. It's good to be here. And before we launch into the topics of the day, 2 minutes after I walked out of the studio last week, we've been talking about jury selection and peremptory challenges and when a systematic peremptory challenge may be disallowed if it appeared to be motivated against a particular minority and what the court had to do to secure and to protect that minorities were not being systematically eliminated from serving on a particular jury. I misspoke myself. The inquiry that must take place and the colloquy between the judge and the lawyers about why the peremptory challenge is being exercised is based upon a case that is the Neal case. And I think I just had a momentary lapse and I called it Reed or something else. And I walked out the door and I said, I referenced the wrong case. It's a Neal challenge and a Neal hearing. So to anybody who is paying close attention and cross-referencing what I say, I want to go on record that as soon as I said it, I know it didn't sound right, walked outside the door from the studio and remembered that I had misspoken. So I feel much better having corrected that.
Well, see, and it just falls in line with the whole John Travolta thing, mispronouncing the lady's name. And
well, I didn't see that.
We all make mistakes.
I'm
right?
completely clueless about that. I have enough faux pas of my own not to keep up with, Mr. Flash Dancing or whatever his name is. Yeah.
And we do it every day. We make mistakes every day. So.
Anyway, well, I had the procedure right. I had all the technical stuff right, and I just misstated the name. But anyway, how have you been?
Pretty good, pretty good. I guess one case that a lot of us are following is that case in South Africa, the Paralympic
the double
case.
amputee. I really don't know any of the facts about that, and I must confess I haven't had time to even read about it in the paper to any great degree. But it sounds like the witness for the prosecution was pretty dramatic from what I saw on his news article this morning.
Was that the one, and I have a question about that actually, if it's the same one. There was one witness who stated that at another point in time, the guy's name starts with a P. I can't remember the defendant's name, but the Olympic guy.
Petrosius? Or
something like that, yeah.
Something like that, yeah.
He had a gun in a restaurant, and it either accidentally went off or whatever, and then he convinced his friend to take the blame. And I
didn't see that.
And I thought, well, why would that have been argued as not pertinent? Like what's that got to do?
Well, all evidence, in order to meet the threshold test of admissibility, has to be relevant and material to the issues that are involved in the particular trial that is being tried. Now, having said that, there may be relevant and material evidence, but if the court determines that the relevancy of that evidence, the probity value of the relative evidence is outweighed by the prejudice that it caused because it is so inflammatory, that the jury would be unable to balance the relative probative value because it would be so overwhelmed by the prejudice or the outrageousness of the evidence. The federal and Florida evidence code is Florida statute 90.403 and rules of evidence in the federal evidence code 403 says that the judge must do a balancing act, and he must balance the risk of prejudice because the evidence is so inflammatory that it might deny due process to the defendant by so inflaming the passions of a jury that it outweighs the probative value even though it's relevant. Classic case in point, accident case. Person is being prosecuted for having caused the accident. The prosecutor has 12 or 15 4x8 or 8x10 glossy color pictures of mutilated bodies in the car. And that's relevant to show mechanics of the injury, cause of death, elements that you'd have to prove. That's relevant. But 12 gory, bloody pictures have such a psychological impact that it would outweigh the jury's ability to weigh that objectively. So the court has the power, if it determines that the balancing act between relative and probative evidence versus this inflammatory type prejudicial effect that it has, the court balances that.
Oh, really? So sometimes, and that explains why I've been thinking all week because of last week's discussion about something you said that made me realize why we, in the public, with the only access we have to the information about what's going on in the courtroom is through the news.
Yes.
And why our opinion is often exactly the opposite of what the jury decides.
Most assuredly. And I think, and I don't mean to be critical of anyone in any profession, they all have a job to do, but I think it would be the height of naivete to think that the people that do the television talk shows, these so-called gurus or talking heads that come in and opine about what's gone on and how it is interpreted and that sort of stuff, that they don't have an agenda or that they're not coming from a background where their opinions are influenced by a particular view and an agenda rather than what is ideally in a trial. The evidence is presented in a sterile fashion under strict control of the judge who administers these rules of evidence to ensure that the most probative evidence and reliable evidence, competent evidence, comes before a jury. And then we have what is which is cornerstone of all litigation, and that is the science and the art of cross-examination. The greatest tool to search for the truth is a competent, experienced, prepared, who's done his homework, his or her homework, cross-examiner, because it is out of that rubbing and scrubbing of challenging the individual's testimony that there is a greater likelihood that the unvarnished true answer will emerge. Doesn't always work that way. System isn't perfect, but that's the theory.
How do you dig deeper when you think a witness is lying? How do you?
Well, that's kind of like asking someone, how do you do brain surgery? Every case is different. It
Really?
starts out with unbelievable, tedious preparation so that you have every fact. If that witness has made any prior inconsistent statements, you need to have those, have them documented. It's really they teach multiple courses in it in law school, and every year I take an extensive continuing legal education update course on the rules of evidence, and it's very, very involved. But in essence, you want to be able to disclose and reveal facts that would show that the statement or the document or the photograph that was being offered into evidence may not be as reliable as the person who offered it would want you to believe it to be.
Are witnesses obligated by law to appear?
If they're subpoenaed.
Okay. So
they don't have to come voluntarily. Someone who's a witness has absolutely no duty to talk to a lawyer on either side voluntarily if they don't want to. They may choose to voluntarily. But if they're subpoenaed, then they have to come to
otherwise
the deposition.
they're in trouble, right?
Sir, that's right. A subpoena is a court order that is issued under the authority of the court to compel the presence of a witness.
All right, and we do have a phone call.
Very good.
By the way, let me invite everybody to call. This is a live show. If you're listening on March 5th, Wednesday, March 5th, 2014, this is a live show. Look on your calendar, and if it's not that date, then you're listening to a pre-recorded show, but let's go to the phone right now. The number is 622-9622, by the way, if you'd like to call John. Good morning. You're on the air with John Fuller.
Yes. Good morning, Mr. Fuller.
Good morning. How are you, sir?
Very good. Thank you. Is the judge the final say on if a jury is hung or not? And does he have the authority to change the decision of a hung jury?
The judge has the authority to declare that the jury is hung. The determination of whether the jury is hung or not is dependent upon the dynamics of the jury. And if after deliberation and appropriate instruction by the court is advised that despite their conscientious best effort, they are irrevocably hung, meaning that they cannot get a unanimous verdict. They are people in the jury room who have strong feelings that are diametrically opposed from their fellow jurors, and if they can't reach a consensus, our law requires that we have a unanimous jury verdict. And if those people deliberating in their good conscience, applying the oath they take to fairly and unbiased consideration of the evidence and to listen and follow the legal instructions given by the judge, when they do that, if they have an abiding conviction that what their opinion is, then they should stick by that conviction. This is not a popularity contest, and you know you're entitled as a juror to your individually held beliefs. And so if they come back and they're deadlocked, then the court would declare a mistrial, and you would have to come back at a later date with a new jury and do it all over again.
So in other words, they're excused from the trial, and that's the end
That's
of
the
it.
end of their jury service, and they will not retry that case. It will be a new jury.
Okay. Well, thank you very much. Very
Yeah,
interesting
good. That's
answer.
a very good question, and I appreciate you calling. In fact, we talked a little bit about picking a jury, or at least the process of interviewing prospective jurors to see, who might be the most appropriate juror for the particular case. And one of the questions that I have consistently, repeatedly asked prospective jurors, Mr. or Mrs. or lady or gentleman, if you have a strong and abiding conviction after hearing all of the evidence presented and the instructions of the court that the evidence does not support a conviction of my client in this case, and you are back in that jury room deliberating, and you find that you are in a minority of one, and 5 of your fellow jurors feel differently than you do you have the courage? Do you have the stamina? Do you have the fortitude to stick by your guns and to maintain your well-reasoned opinion that in your judgment is the correct opinion, and not be swayed by the comments or the pressures that might be exerted on you by other juror members? I don't want somebody in
That's
there
important, yeah.
who isn't a
You don't want a follower, right?
So yeah. Well, in some cases you might like a follower. If I can pick a jury where I see one strong leader who seems to be open to the issues that are favorable to my client, and there are 4 followers along there, that might be exactly the kind of jury makeup that I would like to have.
So are you literally involved with every jury that you are talking to?
Yeah, you get to question them, and
but I mean, you've been part of the selection process, you yourself.
You mean as a lawyer?
Yeah.
Every trial, the lawyers ask the jurors questions before you pick the jury.
Okay, that's what I didn't know.
Yeah. Oh, absolutely. It's called the process of voir dire, V-O-I-R-D-I-R-E. It comes from, I think, actually Old French, but some Latin derivative. It means to speak the truth.
Huh. Yeah, that strength that you just emphasized in your chosen words. I mean, you're good with words. I mean, I can imagine if I was in that seat and you were talking to me, you would be telling me as well as asking me that you want me to be that strong. You want me to be the guy who holds out if I really feel that strong about it.
That's right, and especially if during the voir dire process that particular juror has expressed views that indicate that he would have an open mind and be able to relate to my client.
Interesting. You are a psychiatrist as well as an attorney.
Well, I mean,
in a way, I mean, you have to.
Well, one of the things that big trials have, and this is the way Dr. Phil got his start. He was an unknown psychologist out in California somewhere, and Oprah Winfrey got sued, and her trial team hired Dr. Phil to assist them with picking a jury. They are jury pickers all over the United States. Most of them have PhDs in psychology, and they will work with the trial team. They're very expensive, and you can't do them in every case. Right. And there's 2 schools of thought about it. Some experienced trial lawyers do not subscribe that that's a helpful asset to have. Others think that they can be of benefit. Right. Sometimes they can, sometimes they can't, and you really don't know until you get right in the midst of it. Right. And it is a very expensive proposition, and you can't really, not many cases have the budget to justify hiring a psychologist. But they are some excellent seminars around the country. They are, that where, you go to seminars and you learn the latest in psychological cues, how people react and that sort of thing. And there's some things that are self-evident that we talked about the other day. If you've got a case and the other side is going to call 6 law enforcement officers who are going to be testifying against your client, and you have a prospective juror, and his wife is a law enforcement officer, his father was a law enforcement officer, his brother's a law enforcement officer, chances are he might give a little extra credence to what those witnesses say, because he's been attuned to trust and believe what law enforcement says, over and above what a John Doe citizen who does not have law enforcement officer would say.
The phone number right now is 622-9622 if you would like to speak to John Fuller. Today is March 5th, 2014, just so you know if it's a live show or not. Well, I was in a car accident some years ago. I may have shared this with you, and Dr. Vakori was my doctor, and I know that sometimes he was called as an expert witness, so I wanted to ask you about that, but you do have a call, so I'll put that on hold if you could. You might have somebody with an important question. Good morning. Thank you for calling. You're on the air with John Fuller.
Good morning. I'll try to be brief.
Good morning. How are you?
Fine, thank you, Mr. Fuller. For what you said earlier, if a juror is really excited about exercising their civic responsibility and has a notepad and a pencil, and they are just rip-raring ready to give their full effort to serving on this jury, it seems to me from what you said, Mr. Fuller, that in some cases, one of the attorneys might not be so eager to have that person on the jury. They might rather have somebody that's not ready to, take control and take charge of a jury. And I'll just listen off the air, but could you just kind of respond to that briefly? Thank you.
Sure. Yes. Look, there is no magic formula that is not a precise science. It is, you do the best you can, and you don't get to pre-select the people that are coming in. They come in, and you have 3 strikes that you can discharge people for no cause whatsoever. And when you use those 3 strikes, you have to take whoever is the next juror in the box, good, bad, or indifferent. There are cases where it is troubling as a lawyer who wants a jury that comes in, and I think the best way to describe the ideal jury is one that is attentive, that is bright, that has a completely open mind, and is a clean slate, so that both lawyers get a chance to paint on that slate the picture of the case as they perceive it and as they are arguing it. When you have a witness or juror who is there because they view it as their duty to go out and right the wrongs of society, and I'm not accusing anybody of doing this per se, but you have strong-willed, dominant people who have strong opinions, and they want to right the ills of the world, and they want to use jury duty as the springboard to do that. One of the real difficult questions to deal with is insurance. The insurance lobbyists have spent millions and millions of dollars over many, many years of what has been documented as inaccurate data, but it's designed to infect the average person to think that our judicial system is run amok, and if they give an injured plaintiff a fair award for his or her damages, that the subtle message is your insurance premiums are going to go up. And so you have to deal with that. And one of the ways is folks, based on, the television ads or the editorials or the lobbying campaigns, especially during political years, do you have such strong feelings one way or the other about the issue of a just verdict causing some kind of ripple effect that you would be opposed to based on an alleged insurance crisis? Do you have any of those issues that you feel strongly about? And would you tell me about them? You want to get the juror talking, and then when one technique that is taught and used, and I've used it with some degree of effectiveness, is called looping. And so you get a dialogue going with the juror, and you let them talk. Lawyer ought to keep his mouth shut a bunch. You just kind of get them started talking, so you can find out what's in their hearts, what's in their mind, what's in their gut. And as they are telling you this, then you loop to juror number 2 who's sitting next to him, and you say, Ms. Smith, you just heard Mr. Brown over here say that he thinks that, nobody ought to get more than $1,000 for damages because he doesn't want his car insurance to go up, or he thinks all doctors are gods, and that no matter the fact that the allegation is that the doctor amputated the wrong leg, he doesn't think he ought to get a judgment of more than $10,000 against him because we don't want to run doctors out of the state of Florida. What do you think about that? How do you feel about that? What is your opinion? And that way you then get a dialogue going, so there's a play between, and you see how these people interrelate to each other. That's called looping.
So you are a psychiatrist. So what I started before the call was about the expert witness, and I used my own situation, although I never had to go to court. But I remember Dr. Vakori saying he is called as an expert witness quite frequently. Does the doctor that's working with somebody, is that doctor not able to be in court? Like, for example, could Dr. Vakori have come in for me, or would the court say, no, you have to have somebody who doesn't even know you be the expert witness?
No, you know, he's your treating physician. You have an absolute right. He's the one.
Okay.
He's the one who is providing care for you. He's the one that worries about, are you in pain? Is my treatment helping? What can we do to make you more comfortable? And this is what we're doing, and this is what it takes. And even though when we finish with our best efforts, you're still going to have residual problems and you're going to need future medical stuff. That's your treating physician. And he's your most important ally because he's had hands-on. He's had the chance to see and observe and treat you. And so, yeah. Now, the other side has a right to call what the opposing side, likes to euphemistically call an independent medical examiner. Well, these guys aren't independent. They're hired by the defense insurance company to come in and examine plaintiffs and then come to court to testify. And they are not there to treat them. They don't prescribe. They see them one time, and they form an opinion that, well, you're not hurt, and I don't think you need any more treatment, and you're going to be fine, and you can go back to work. And the treating physician who's treated them and is trying to help them get better disagrees with that. And they come in and they want to testify as an independent medical. Well, let me tell you, when I cross-examine them, I refer to them as a litigation expert. I'm entitled to know how many cases they've worked for that defense lawyer, what percentage of their income comes from doing examinations for him, how many times has he testified. And many of those people don't have offices. They don't actually even treat people. You're not trying to help you're not trying to help my client
Shoot him out
better.
of the water with
You're
that.
not trying to help you're a litigation witness. You're hired to come into court and to give opinions on behalf of one of the litigants. You're part of the team, aren't you? I don't think you could say part of the team. I think that would be a little over the top.
But one of my favorite things about this show, John, is when you get into that mode and we can kind of get an idea of what you're like in the courtroom. And
I care, you know, first of all, Bobby Lee Cook, who I've referred to on this show a lot, if you can't be passionate about representing the interest of your client, you're the wrong lawyer for that client. And some lawyers, can't do it.
That makes sense,
when if you have a client that for whatever reason you can't relate to and you can't be passionate about that person's claim, then you're the wrong lawyer for the case and you ought to get out of it.
Well, you'd be the right lawyer if I ever need you.
You're very kind. I hope you never need one. I hope you live happily ever after.
Yeah, really. All right, John, how do we get a hold of you?
Our office in Ocala, the phone number is 352-547-4292. The name of the firm is Fuller & Fuller. We help folks in litigation matters of injury cases or business and commercial cases, select complicated, complex family law matters, and Janet specializes and does 100% Social Security disability cases. So if you've been injured or have a disability and you've been denied and you are in need of disability, Janet is the one who specializes in that. We have a toll-free number, 855-534-2565. We have offices in Ocala and the Villages, and if you have a legal problem, if you've been injured in a case or you have a domestic issue or a business commercial dispute and like to speak with us in an individual conference, we'd be happy to schedule one.
Always good stuff, John. And call us here at the radio station if you need John's information repeated. We'll be glad to do that for you. Thank you, John.
Thank you, Larry. It was fun.
Good stuff. We'll take a
Always
little
pleasure.
break and be right back.
Ocala's information station, 1370 WOCA.
Ocala.
ABC News Now. I'm Karen Chase. Target's chief information officer is resigning as the retailer overhauls security in the wake of that massive data breach. Target disclosed that millions of customers' accounts had been compromised. A New Jersey judge denied